Several courts over the last few years have ruled that laws prohibiting same-sex marriage are unconstitutional, and opponents of same-sex marriage have filed appeals to the Supreme Court, resulting in those rulings being stayed until the Supreme Court hears them. On October 6, 2014, the Supreme Court decided that it will not take the cases that immediately affect Indiana, Oklahoma, Utah, Virginia, and Wisconsin. So the lower court rulings against laws prohibiting same-sex marriage in those states stand, and the stays on those rulings have been lifted. Same-sex marriage is now legal in those states. However, many of the courts with stayed rulings were circuit courts whose rulings cover more than just the states from which the relevant cases originated. Those additional states will eventually have to abide by the rulings of the circuit courts, but some of them can continue to refuse to issue marriage licenses until after a few extra steps are taken. For example, ABC News says that South Carolina Attorney General Alan Wilson said he will continue to fight to uphold the state constitution's ban on gay marriage. He pointed out that a judge has not ruled on a lawsuit by a gay couple legally married in Washington, D.C., seeking to overturn the South Carolina gay marriage ban. A lawyer for the same-sex couple, Carrie Warner, said she will soon file paperwork asking a federal judge to immediately rule in their favor. USA Today says the Kansas ACLU plans to get things out of the way in that state pretty soon, too. They said the ACLU earlier had decided to wait to see what the Supreme Court would do with the cases that came up from the 10th Circuit before challenging the Kansas same-sex marriage ban. Now the ACLU plans to file a lawsuit in federal court and likely will ask for a preliminary injunction blocking the Kansas law. Marriages can proceed in the additional states of Colorado, Kansas, North Carolina, South Carolina, West Virginia, and Wyoming when their attorneys general say so. Colorado's attorney general is in the process of filing such a motion, or after the lower courts begin to explicitly order the states to stop enforcing the current prohibitions.